Dennis versus United States by Laura Sayú Sánchez. Facts. Petitioners were indicted in July 1948 for violations of the conspiracy provisions of the Smith Act 1946 during the period of April 1945 to July 1948. The pretrial motion to quash the indictment of the grounds, inter alia, that the statute was unconstitutional was denied. United States versus Foster. The case was set for trial on January 17, 1949. A verdict of guilty as to all the petitioners was returned by the jury on October 14, 1949. The Court of Appeals affirmed the convictions. The indictment charged the petitioner with willfully and knowingly conspiring, first, to organize as the Communist Party of the United States of America, a society group, an assembly of persons who teach and advocate the overthrow and destruction of the government of the United States by force and violence, and second, knowingly and willfully to advocate and teach the duty and necessity of overthrowing and destroying the government of the United States by the force and violence. The indictment further and adds that Section 2 of the Smith Act proscribes these acts and that any conspiracy to take such action is a violation of Section 3 of the Act. Smith Act, Section 2. A. It shall be unlawful for any person, first, to knowingly or willfully advocate, advise, or teach the duty, necessity, desirability, or propriety of overthrowing, of destroying any government in the United States by force or violence, or by the assassination of any officer of any such government. Second, with intent to cause the overthrow or destruction of any government in the United States to print, publish, edit, issue, circulate, sell, distribute, or publicity display any written or printed matter advocating, advising, or teaching the duty, necessity, desirability, or propriety of overthrowing, of destroying any government in the United States by force or violence. Third, to organize or help to organize any society, club, or assembly of persons who teach, advocate, or encourage the overthrow or destruction of any government in the United States by force or violence, or to be or become a member of or affiliated with any such society, group, or assembly of persons, knowing the purpose thereof. B. For the purpose of this section, the term government in the United States means the government of the United States, the government of any state, territory, or possession of the United States, the government of the District of Columbia, or the government of any political subdivision of any of them. Section 3. It shall be unlawful for any person to attempt to commit or to conspire to commit any of the acts prohibited by provision of this title. Legal issue. Two questions. First, whether either Section 2 or Section 3 of the Smith Act inherently or as construed and applied in the instant case violates the First Amendment, freedom of expression, and other provision of the Bill of Rights. Second, whether either Section 2 or Section 3 of the Act inherently or as construed and applied in the instant case violates the First and Fifth Amendment because of indefiniteness. Rule of law. No. We hold that Section 2 and 3 of the Smith Act don't inherently or as construed or applied in the instant case violate the First Amendment and other provision of the Bill of Rights, or the First and Fifth Amendment because or indefiniteness Petitioners intend to overthrow the government of the United States as speedily as the circumstances will permit. Their conspiracy to organize the Communist Party and to teach and advocate the overthrow of the government of the United States by force and violence created a clear and present danger of an attempt to overthrow the government by force and violence. They were properly and constitutionally convicted for violation of the Smith Act. The judgments of conviction are affirmed. When facts are found that establish the violation of a statute, the protection against conviction afforded by the First Amendment is a matter of law. The doctrine that there must be a clear and present danger of a substantive evil that Congress has a right to prevent is a judicial rule to be applied as a matter of law by the court. The guilt is established by the proof of facts whether the First Amendment protects the activity which constitutes a violation of the statute must depend upon a judicial determination of the scope of the First Amendment applied of the circumstance of the case. Likewise, the Supreme Court are in accord with the court below which affirmed the trial court that the required danger exists. The mere fact that from the period 1945 to 1948 petitioners' activities didn't result in an attempt of overthrow the government by force and violence is of course not answer to the fact that there was a group that was ready to make the attempt. The formation by petitioner of such a giant organized conspiracy with rigid disciplinary members subject to call when the leaders, the petitioners, felt that the time had come for action because similar uprisings in other countries and petitioners were, in the very least, ideologically attuned, they need convince them that their convictions were justified on this score and this analyze dispose of the contention that a conspiracy to advocate, as distinguished from the advocacy itself, can't be constitutionally restrained because it comprises only the preparation. It is the existence of the conspiracy which creates the danger. If the ingredients of the reaction at present, we cannot bind the government to wait until the catalyst is at. The Supreme Court agrees that the standard is not a neat mathematical formulary. Like all verbalization, it is subject to criticism on the score of indefiniteness, but petitioners themselves contend that the verbalization clear and present danger is proper standard. The court sees no different from the standpoint of vagueness, whether the standard of clear and present danger is one contained in the statute, or whether it is the judicial measure or constitutional applicability. The court have shown the indeterminate standard they think it will serve to indicate to those who would advocate constitutionally provided conduct that there is a line below which they may not go. Where there is doubt as to intent of the defendants, the nature of the activity, or their power to bring about the evil, the court will review the conviction with the scrupulous. Thanks.